Hello, my name is Peter Walsh. I'm an attorney licensed to practice law in the states of Wisconsin, Illinois, and Florida. My legal practice focuses on the areas of estate planning and asset protection planning. In this presentation, I will be discussing asset protection planning for long-term care. Specifically, I will be summarizing some of the rules and common techniques involved in this planning under the laws of the state of Wisconsin. More detailed information is available online at www.wismedicaid.com. This presentation is intended to provide general answers to commonly asked questions in this area. It is not intended to constitute legal advice to a specific situation. You should consult with an attorney regarding your particular circumstances. Please contact me with any questions you may have on this subject. Throughout this presentation, I will be using the term applicant. Applicant refers to an individual in need of long-term care or a person applying for long-term care insurance or Medicaid benefits. What is long-term care? Long-term care describes the care required for an applicant who, due to a disability or old age, needs assistance performing the activities of daily living. Activities of daily living include eating, bathing, dressing, and toileting. Long-term care services are generally necessary when an applicant cannot independently perform two or more activities of daily living. This care can be provided by caregivers in the applicant's home or through services offered in an assisted living or nursing home. What is long-term care asset protection planning? As discussed in this video, long-term care asset protection planning generally involves the purchase of an insurance product or the transfer of assets. Insurance can provide a source for paying for care or a means of recouping funds spent on care, and assets can be transferred to shelter wealth in the event of a long-term care need. Why is it important to plan for long-term care? Long-term care is extremely expensive. For example, the median cost of an assisted living or a nursing home in the Milwaukee area exceeds $4,000 and $9,000 per month respectively. Care at home is similarly expensive. Unfortunately, there is a strong likelihood that you may eventually need such expensive care. However, the amount of these costs can be substantially reduced through proper planning. How can you plan to cover the cost of long-term care? Planning generally involves obtaining insurance, either private or public, to help cover the cost of long-term care. Private insurance comes in the form of life or long-term care insurance, while public insurance comes through Medicaid. Private insurance can provide a dedicated funding source for long-term care. To qualify for private insurance, an applicant must be in reasonably good health and be able to pay premiums. For those who can obtain private insurance, Medicaid may be available. Medicaid eligibility is the opposite of insurability for private insurance. Unlike private insurance, to be eligible for Medicaid, an applicant must have an immediate need for long-term care and lack the resources to pay for it. Why can't I just rely on Medicare? Medicare coverage for long-term care is limited. For example, Medicare coverage for a nursing home stay is limited in terms of days. Specifically, Medicare pays the entire cost for the first 20 days and only a portion of the cost for the next 80 days. After 80 days, a resident may have to pay for all the nursing home costs. Coverage offered by private insurance and Medicaid is not so limited. How can private insurance be used in long-term care asset protection planning? Private insurance can be used to recoup funds expended on long-term care. For example, traditional life insurance can restore funds expended on the applicant's long-term care following his death. Recoupment may also come through long-term care insurance. This type of insurance provides funds for long-term care expenses during the applicant's life. The benefits of long-term care insurance may include payment for care at home, an assisted living, as well as a nursing home. Moreover, private insurance may also include a death benefit. The benefits paid on certain qualified long-term care insurance policies can also increase an applicant's Medicaid asset limit. For instance, if a single individual has a qualified long-term care policy with a total of $100,000 benefit, this person's Medicaid asset limit may be increased from $2,000 to $102,000. The disadvantage of private insurance stems from insurability and affordability. Private insurance can only be purchased by those who have no immediate need for it and who have the ability to pay premiums. Thus, private insurance requires both advanced planning to secure coverage and substantial resources to pay premiums. What is Medicaid? Medicaid is a government insurance program which covers the cost of long-term care. For an elderly applicant, Medicaid is commonly used to cover the cost of a nursing home and an assisted living. In some respects, Medicaid is the opposite of private long-term care insurance. To qualify for private insurance, you must be healthy and able to pay premiums. Conversely, to qualify for Medicaid, you must need medical assistance and lack the means of paying for it. Nevertheless, Medicaid does not provide inferior coverage. Most nursing homes accept Medicaid, and federal law prohibits nursing homes from providing less care to a resident because he receives Medicaid benefits. How is Medicaid eligibility determined? To qualify for Medicaid benefits, an applicant must be both functionally and financially eligible. To be functionally eligible, an applicant must have a chronic condition which causes the applicant to need assistance with 2 or more activities of daily living. To be financially eligible, the applicant's income and assets must be below certain minimal levels. In addition, the date on which Medicaid eligibility begins depends upon whether the applicant made any gifts in the 60 months preceding the Medicaid application. Such gifts can cause the applicant to be ineligible for certain Medicaid benefits for a period of time. If there are no such gifts, Medicaid eligibility begins upon the first day of the month in which the application is filed. What is the income limit for Medicaid? The income limit is not a fixed number. It depends on the applicant's cost of care. If the applicant's cost of care exceeds his income, then he satisfies the income limit. The applicant must use his income towards his cost of care, and Medicaid pays the excess. For example, if an applicant has $3,000 of monthly income and is in a nursing home which costs $6,000 a month, the applicant satisfies the income limit because his cost of care exceeds his income. What is the asset limit for Medicaid? The hardest part of Medicaid eligibility is satisfying the very low asset limit. For a single applicant, the limit is $2,000 of countable assets. For a married couple, the asset limit can be substantially higher because of spousal impoverishment protections. To the extent the applicant's countable assets exceed this limit, the excess must be spent down. The spend down of assets to qualify for Medicaid is referred to as a Medicaid spend down. Not all assets are countable for Medicaid purposes. Specifically, countable assets do not include unavailable assets and exempt assets. Unavailable assets are assets that cannot be converted to cash within 30 days. Examples of unavailable assets include property listed for sale, a life estate interest in real estate, and certain annuities and promissory notes. Exempt assets are assets specifically protected by statute. They include the value of an applicant's home, one car, prepaid funeral funds, and assets in a qualified special needs trust. Are there any protections for the spouse of a Medicaid applicant? The Medicaid rules provide protections to the spouse of a Medicaid applicant who lives at home. These protections are referred to as spousal impoverishment protections. The protected spouse is referred to as the community spouse. These protections are intended to prevent the community spouse from being impoverished by the applicant's nursing home costs. Spousal impoverishment protections generally allow the community spouse to retain substantial assets and income. For example, Medicaid exempts from the applicant's countable assets the community spouse's IRA and tangible personal property. It also allows the community spouse to own a home of any value. Medicaid further increases the countable asset limit of a married applicant by the amount of the community spouse resource allowance, which may be as much as $123,000 in 2019. The community spouse is further afforded certain income protections. First, the community spouse's income is not considered in determining whether the applicant's spouse is income eligible. Second, if the community spouse's income is below the minimum monthly maintenance allowance of about $3,000, some of the applicant's income can be transferred to the community spouse. What is a Medicaid spend-down? A Medicaid spend-down describes the expenditure of excess countable assets to bring them down to the level of Medicaid eligibility. For example, if an applicant has $10,000 and a Medicaid asset limit of $2,000, the applicant may need to spend down $8,000 to qualify for Medicaid. Assets can be spent down on long-term care expenses, such as the cost of a nursing home stay, or assets can be expended on exempt assets or converted to unavailable assets. While spending all excess countable assets on long-term care expenses can result in Medicaid eligibility, this approach limits the applicant's options once assets are spent down. Conversely, expending excess countable assets on exempt assets or making these assets unavailable may allow the applicant to qualify for Medicaid while retaining some benefits from the assets. Medicaid asset protection planning often involves converting countable assets to exempt or unavailable assets. For example, countable funds can be spent on the applicant's home to convert the funds into an exempt asset, or they can be used to purchase a Medicaid qualified annuity to make them unavailable. Can assets be given away to qualify for Medicaid? An applicant generally cannot give away assets to become eligible for Medicaid. Such gifts constitute divestments that cause an ineligibility period. Specifically, the value of all divestments made within a look-back period are added together to determine a penalty period. A divestment is a gift of countable assets or income. The look-back period is a 60-month period prior to the date of the Medicaid application, and the penalty period is a number of days following the date of the Medicaid application during which the applicant is ineligible for Medicaid because of the divestment. The penalty period is determined by dividing the total of the divestments made during the look-back period by the average daily cost of a nursing home. The result is the number of days of the penalty period. For example, if the average daily cost of a nursing home is $300 and the applicant has $9,000 in divestments, the penalty period is 30 days. This is determined by dividing $9,000 by 300. Certain gifts are specifically excluded from the divestment rules, so they do not cause a penalty period. For example, gifts to a spouse or to a disabled child are not divestments. Can Medicaid take an applicant's home? Medicaid does not take an applicant's home, nor does the state require a home to be transferred for Medicaid eligibility. Instead, the state may place a Medicaid lien on an applicant's home to recoup Medicaid benefits expended on the applicant. A Medicaid lien entitles the state to a portion of the proceeds from the sale of the home. For example, if the applicant received $100,000 of Medicaid benefits, the lien on the home would equal $100,000. If the home was sold for $200,000, the state would receive $100,000 and the applicant or his heirs would receive the balance. A Medicaid lien cannot be placed upon an applicant's home if the applicant, his spouse, or his minor or disabled children reside in the home. How do I plan for Medicaid eligibility? Medicaid eligibility planning generally falls into one of two categories. The first category involves sheltering assets before long-term care is needed in order to protect the assets from a Medicaid spend-down. For example, a parent can shelter an asset by transferring it to an irrevocable trust or a child more than 5 years before a Medicaid application is filed. Gifts made more than 5 years before a Medicaid application do not cause a penalty period, regardless of the value of the gift. The second category involves sheltering assets when long-term care is immediately necessary because the applicant is in a nursing home. Substantial wealth can be preserved even after the applicant is in a nursing home. For instance, countable assets can be converted to exempt assets by making repairs to the applicant's home, prepaying funeral costs, or transferring assets to a qualified supplemental needs trust. Countable assets can also be converted to unavailable assets by listing real property for sale or exchanging liquid assets for a qualified annuity or promissory note. Through such techniques, Medicaid eligibility can be obtained without spending down all the assets on medical expenses. How can private insurance be used in Medicaid eligibility planning? Private life and long-term care insurance can be a valuable component of Medicaid eligibility planning. As previously discussed, insurance can be used to recoup funds expended during a Medicaid spend-down, and private long-term care insurance can be used to increase the Medicaid asset limit by the amount of the benefit paid under the policy. Long-term care insurance can also be used to pay for an applicant's care during a penalty period. For example, in Wisconsin, a long-term care policy providing for 3 years of coverage may provide funds to cover the cost of a penalty period for a $300,000 divestment. Can trust be used in Medicaid eligibility planning? Trust can be used in Medicaid eligibility planning to shelter assets from a Medicaid spend-down. In general terms, a trust is a legal entity like a corporation or a partnership, which can be used for the ownership and management of assets. The person who creates a trust is referred to as the grantor, while the person who manages the assets is referred to as the trustee. The trustee is to manage the trust assets for the beneficiaries of the trust. Revocable trusts are the most commonly used type of trust. The term revocable means that it can be changed or terminated by the grantor. Revocable trusts are often used to transfer assets upon the death of the grantor to his beneficiaries without probate. Because a grantor controls the assets of a revocable trust, the assets of a revocable trust are considered available to the grantor and countable for Medicaid purposes. Thus, revocable trusts do not protect assets from a Medicaid spend-down. Conversely, irrevocable trusts can shelter assets from a Medicaid spend-down. These trusts are referred to as irrevocable because the grantor does not retain the power to modify or terminate the trust. A grantor can transfer an asset to an irrevocable trust to change the ownership of such asset from the grantor to the trust. This change to the ownership can make the asset non-countable for Medicaid purposes. Irrevocable trusts are often used to make life insurance and real estate non-countable for Medicaid purposes. Supplemental needs trusts are also commonly used in Medicaid planning. These are trusts in which the trustee has broad discretion as to the manner in which distributions are made to the beneficiary. Because of this broad discretion, the assets of a supplemental needs trust may not be countable for Medicaid purposes. This allows a beneficiary to qualify for Medicaid while still being able to receive benefits from the supplemental needs trust. Essentially, if the trust eliminates the ability of the grantor or beneficiary to compel a distribution of the trust assets, the assets may be considered non-countable for Medicaid purposes. Careful drafting and proper timing is required for a trust to shelter assets for Medicaid purposes. For example, the transfer of assets to an irrevocable trust within 5 years of the grantor's Medicaid application could constitute a divestment and result in a penalty period. Thus, the use of a trust in Medicaid planning requires the assistance of competent legal counsel. How can assets be protected from a Medicaid spend-down once the applicant is in a nursing home? There are planning techniques for sheltering assets from a Medicaid spend-down even after an applicant is in a nursing home. They include expending funds on exempt assets such as prepaying funeral expenses, paying down the mortgage on the applicant's home, making improvements to the applicant's home, and upgrading his vehicle. Expenditures of countable funds on exempt assets converts the funds into exempt assets which do not need to be spent on. Another option is to convert countable funds into unavailable assets. For example, real property can be made unavailable by listing it for sale with a real estate broker. Cash investments can be made unavailable through the purchase of a Medicaid qualified annuity or promissory note. A Medicaid qualified annuity or promissory note converts an available cash sum into an income stream in which the principal is not available. There is also the option for an applicant in Wisconsin to transfer countable assets into a pooled special needs trust to be held for his benefit. In Wisconsin, a transfer to a pooled trust does not constitute a divestment if the trust provides for the state to be paid back upon the applicant's death for Medicaid benefits he received during life. Accordingly, in many cases, steps can be taken to shelter assets even after long-term care becomes necessary. In closing, unfortunately, there is a strong likelihood that at some point you may need long-term care. The cost of such care can be catastrophic. Fortunately, you could substantially reduce these costs through proper planning. More information on this topic is available online at www.wismedicaid.com. Thank you for viewing this video. We hope you found it helpful. Please contact us with any questions or comments you may have on this subject.